According to the police report, what you just pled to, she was walking with your son in a park and you came up behind her, pulled her by her hair, dragged her by the hair and punched her. So I'm trying to figure out why you hitting on a 14-year-old.
I was angry. I was really, really upset. My son wasn't going down any wrong
That
path
opening
until he met this
allegation
girl.
is already shocking. But now the courtroom has to answer a much bigger question. Is this defendant actually admitting guilt or simply taking a plea deal to avoid an even bigger risk? As this hearing unfolds, pay close attention. Sometimes the most revealing moments aren't the evidence. They're the defendant's own words.
Court is calling 2022 CR 0054, State of Texas versus Angel Montoya. Can I have parties announced for the record for the state?
Not done for the state.
Defense.
Ed Piper from Ms. Montoya.
Are you Angel Montoya?
Yes, ma'am.
Did you understand you're charged with injury to a child, bodily injury intentionally or knowingly? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison? Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her? Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Montoya, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial, showing you
Here's
the plea
something
bargain
many
page that
people
you
don't realize. A plea agreement isn't just about avoiding prison. It can trigger long-term consequences that follow someone for years. Restrictions on firearms, parenting rights, probation conditions, and future legal complications. Those consequences can last well
right to
beyond the
jury
courtroom.
trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is recommending deferred adjudication. There's an affirmative finding of family violence, no contact with Ariana Garza. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as a primary custodial parent?
Yes, ma'am.
Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No.
Next, I'm showing you outside the agreement. The state is recommending that your community supervision be for a term of 4 years. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. State offer states one in attachments. We did review them, no, Judge.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing? Anything you might want to say on behalf of your client?
Judge, several things. She's 33 years old. This case happened about 3.5 years ago. Since that time, everything's been perfect.
This is where the hearing takes a dramatic turn. Up to this point, everything has been routine, legal paperwork, rights, and formalities. But now the judge steps away from procedure and starts asking the question everyone watching is thinking. And the answer that follows changes the entire tone of the hearing.
It's happened to be the girlfriend of her son, who she thought was leading him down the wrong path. Certainly not handled correctly, but the boy does not date or see the girlfriend anymore. Mom has not seen this girl since that time. She does have full-time employment as a night auditor of a local hotel. She is gainfully employed. She does other side work with other groups that she can tell you about if you'd like to hear, because I'm not familiar with the groups that she works with.
So how old was your son's girlfriend?
At the time, my son was 15, so I was swimming around 14, 15.
All right, so why are you beating up on a 14 or 15-year-old?
I'm not the one who did it.
I'm sorry, what?
I didn't. I've never seen this. Like, I've seen the girl in person, but I've never.
Now, according to the police report, what you just pled to, she was walking with your son in a park and you came up behind her, pulled her by her hair, dragged her by the hair and punched her. So I'm trying to figure out why you hitting on a 14-year-old. I'm sorry, what?
I mean,
There's a video according to the police report.
it's
Did you catch that? This is a pivotal legal moment. If someone truly maintains they're innocent, a jury trial is the opportunity to challenge the evidence. By declining that option while continuing to question the allegations, the defendant puts herself in a difficult position. It's exactly why the judge immediately presses for an explanation instead.
I. Hmm. I know there's a video. I know it's a blurry video. I know it looks like me.
So are you saying that this is just all made up?
Oh gosh.
No, if you want a jury trial, we will give you a jury trial.
I mean, I don't want it to go bad and make it.
The
and I
judge
go
has
to
heard the
prison for
explanations,
something I didn't do.
but now comes the only thing that really matters, the sentence. Notice how the court separates frustration from punishment. The emotional exchange may grab headlines, but every condition imposed has legal significance. The next few seconds will determine what life looks like after this
I
hearing.
go to prison for something I didn't do.
Well, here's the thing. If you're saying you didn't do this and you want a jury trial, then guess what? In the 187th, I will put cases to trial and we will give you your jury trial. But what I'm reading in the police report, there is a video. And yeah, it's saying that you pulled her hair, you beat her up.
Yeah, I'm aware of what she said I did.
So your only question is, do you want a jury trial or not?
I don't want to do a trial.
All right. So then we're back to the point. Why are you pulling on a child's hair?
So I don't know. I was angry. I was really, really upset. My son wasn't going down any wrong path until he met this girl. They were doing drugs. He was running away. He was stealing cars. I was just trying to be a good parent.
Well, I mean, how is it a good parent to beat up somebody who's dating your son? Why do you think that she's in charge of your son's actions? Did she put a gun to his head and say, do these drugs with
Oh,
me?
she told my son she was pregnant.
All right. Then people need to start supervising their children better.
That's true.
I'm going to sentence you to 6 years deferred adjudication. There's an affirmative finding of family violence, no contact with Ariana.
One decision, one moment of anger, and now years of supervision, a jail sentence, parenting classes, community service, and lifelong legal consequences. Cases like this raise a difficult question. When does protecting your child cross the line into committing a crime yourself? Share your thoughts below, but remember, disagreement is one thing. Violence is
With
another.
Ariana. That's Ariana Garza. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular UAs. No unsupervised contact with minors. 200 hours of community service restitution. I'm going to order parenting classes. Once she's completed parenting classes, that will be deemed satisfied. There's to be field visits, one time per month for 3 months. And there's to be 30 days in the Bear County Jail as a condition of probation. Is there anything else she needs? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Good luck.
Judge, as far as the 30 days, since that was not part of what we had anticipated, can she either have time to turn herself in Friday or do weekends?
No, they don't do weekends anymore at the jail.
So I gotta go to jail for 30 days?
Yes.